Hi, and welcome to the Law Simplified. I'm Shavin Bandadnayaka. Welcome to another SQE1 Insight session. Today, we're going to have a look at a very interesting topic outline, or a module outline rather, which is dispute resolution. Now, if you've gone through the introduction insight session for SQE1, which you can access through the link in the description or through the card that will appear on top somewhere along with this live stream broadcast, you'll notice that in terms of the module breakdown as such, there are several modules that are interconnected with one another. Now, in the context of civil law, for the SQE1, you'll have modules like dispute resolution, business law and practice or BLP, tort law, contract law, and a bit of legal systems. Coupled together, or rather if you consider this particular cluster of modules together, they intertwine and they talk about similar aspects of the law. So I do recommend you first having a look at the introduction session as well after you've gone through this. It will be accessible through the playlist as well as the links in the description and up top. Right. Now, just like we looked at in a previous insight session for criminal practice, what we're going to do is have a broad understanding or have a look at the topics that are covered in this particular module. Now, dispute resolution, as you might see, is a fairly lengthy module as such, not to mention in terms of the depth of procedural requirements that you might need to know from a day one solicitor's perspective. It's quite a handful at that. But just like the other modules as well, criminal practice, later on what we will cover in another insight session, which is property practice, and even wills and administration of estates. All of these modules, and this is the best way that I can sort of impress upon you, anyone who's interested in getting into the SQE stream, specifically SQE1, which is an examination that's dealt with from a multiple choice best answer secures perspective. It's imperative essentially that you know the crux of the main topics in a manner that is holistically connected to one another. So since we're doing dispute resolution or DR, let's have a look at how this particular module is structured. Now, I'd highly recommend having a look at the comprehensive online law school library in the event that you might not be familiar with some of the modules that I've just mentioned in terms of the substantive aspects such as tort law, contract law, and so on. But later on, you'll be able to have a look at the description or the cards that will appear and enroll in the SQE1 Comprehensive Prep Masterclass webinar series that will commence in lieu or rather in relation to the SQE1 examinations themselves. Okay, now in this particular module, in this particular subject area in terms of dispute resolution, a number of important factors have to be first sort of outlined. First and foremost, you'll notice that the modules that are there, or rather the topics that are being covered, parallel with either tort or contract law claims, so to speak, that might come before a court of law. So from a day one solicitor's perspective, what they're actually testing you out is on the procedure of bringing about a claim to a court of law. What's interesting, however, is that subsequent to the Wolf reforms, in terms of the Access to Justice Act of 1999, the predominant objective of the court process is actually to keep people away. So as a result, this is reflected in the dispute resolution process, and even in the examination, that's what you're tested on as well, pervasively, whether you understand that commercial litigation is the last option as such. Now, if you have a look at this particular module, you'll notice from all of the topics, essentially, it's broken into three parts. The first part, effectively, is in relation to doing everything outside of a court process. Now, mind you, from the perspective of this particular module, a large chunk of it, I would argue almost 50% of it, is devoted to the processes of determining whether commercial litigation is what you actually need, and in the event that there are other means of alternatively resolving disputes, or ADR, so to speak, looking at measures of arbitration, conciliation, and mediation, and seeing the pros and cons of it based on the client that you're representing and the circumstances that you're presented with. That's on the one side. In the event that commercial litigation is the only way to go about things, in that situation, then we look at considering where exactly the proceedings are to start, for instance, based on the nature of the claim, whether it's a specialty claim, the value of the claim itself, and we'll look at the different tracks, for example, that cases go into. It's mind you, a very interesting module. It's procedural, yes, but it's interesting nonetheless. Then we look at serving of proceedings, where how exactly the commencement of the process is to take place, the process of serving a claim, the reply, the defense being submitted with an intention to defend, for example, statement of case, basically everything that you need to know about setting up a case for trial is what you look at in the first part of dispute resolution. This takes up a relatively large chunk of the module as well, and it does take time within the webinar program that I'll be conducting also. So it does pay dividend to have an understanding of contract law and tort law to begin with, but essentially SQE1 for non-law graduates will also have the masterclass webinar series, essentially will also have the covering of those modules in a relatively salient or a summary form. But I do recommend having a look at that substantive component of the law, at least separately, before jumping into DR, or dispute resolution. Right, now having looked at that first part, once it has come to a point of court, once you are actually at the door of the court, so to speak, then we look at the second part of it, which entail the rules pertaining to the actual trial and the trial itself. So we'd go through aspects such as interim applications, when you have parties that might want to consider looking at an immediate solution before going into the full trial. For example, they're seeking something like an injunction or specific performance. Someone has gone about, deconstructing or dismantling or demolishing a particular building. There is a dispute, sure, but you want to prevent any irreversible damage, so to speak, before you go into the actual trial. So you might want to have certain interim applications to be heard. How exactly those are to be done. Case management, depending on the value of the claim as well as the nature of the trial, a judge might get involved in order to have case management conferences to make sure that all the parties are on the same page and the pre-action protocols are fulfilled. We look at those as well as as the second part of dispute resolution. Particularly salient rules of evidence will also be considered, and the rules pertaining to disclosure, what you need to divulge or disclose to the other party, what are privileged information, when privilege is lost, and so on. All things considered, then you consider the actual trial itself, from bundles to be submitted, the submissions themselves. But note that in terms of SQE1, we don't go in depth into the actual structure, the format, and the templates as such. We are only concerned about the procedural salient aspects of what needs to be done as opposed to how that is done as such. All things considered, the final crescendo of this module is to look at what opportunities of appeal would be there and how exactly judgments are enforced by court. Because there are instances where trial takes place, a judgment is handed out or meted out, but the party who has lost out has not fulfilled their part of the bargain. Therefore, enforcement of judgment is very essential. It's important to make sure that all the parties are on the same page and whatever the court's decision or the mandated decision is followed through. Right. Now, dispute resolution, as I mentioned, is part of a cluster of modules. So it's always good to study and prepare for it together because it does intertwine between different modules, and your understanding of all of it is necessary to mastering each individual one of it. So that would mean dispute resolution, business law and practice, contract law, tort law, and a bit of legal systems as well. If you'd like to have a broader understanding of each individual module, perhaps you want to go about it and prepare for the SQE1 on your own, I'd highly recommend the comprehensive online law school platform, which is not only complete in a structured manner to help you not just pass but ace the examinations in terms of the SQE1, but also is complete with a comprehensive set of mock examination questions in a format that is paralleling itself to the actual SQE1, FLK1 and FLK2 as well. So I'd highly recommend that in the event that you want to prepare on your own. But if you'd prefer to join the global cohort for the SQE1 Prep Masterclass webinar series, have a look at the links in the description or the card that will appear in this broadcast as well. Once we go through the insight sessions for most of these modules, you'll be able to get a broad-based understanding of it. I do recommend having a look at the very first insight session that we've conducted, where I break down each individual module succinctly so that you have an understanding of how it fits into the grander scheme of things. Okay, I intend to have a few more insight sessions that break down the different modules over time before we commence the masterclass webinar series or the program. So do tune in, make sure you subscribe to the Law Simplified channel, and do click the bell icon so that you get notifications as we stream these insight sessions in advance so that you can carve out the relevant time. I do deal with a lot of time zones, so you have to bear in mind sometimes you might not be able to watch it live since I have to account for different sets of countries, sets of students in different time zones. Right, but that being said, until the next time we speak at another insight session, have fun, stay safe, and as always, obey the law.